Good morning, Internet, or good afternoon, or whatever time it is when you're watching this. Maybe it's 4 in the morning and you want to check out episode 6 of Fireside Chats. My name is Will Creeley. I am the Senior Vice President of Legal and Public Advocacy here at Fire. Always have to remember that one. I'm joined for this 6th episode by Samantha Harris. Sam, what's your title?
I'm the Vice President of Policy Research.
That's right. And my esteemed colleague, Ari Cohn, in from Chicago. Ari, you are Director of our Individual Rights Defense Program, yes?
Yes.
All right. And Adam Steinbaugh, Senior Program Officer?
I think so.
I think so. We'll go with that.
I always feel like we need to move to straight Masonic titles. You know?
Yeah, we could. I would like to be head coach at Fire one day. Right now, I'm maybe just defensive coordinator. All right, let's get started. We have a lot to talk about. It is the end of January, and what do you know? The year has begun with a bang here at Fire. Januaries are usually pretty busy for us. It's the beginning of the spring semester. Spring feels a long way off here in Philadelphia, but there's plenty
Try coming to Chicago.
Yeah, that's right. I know. That's right. Plenty of stuff to talk about. Let's start with the latest from Essex County College, where folks will remember we had filed a lawsuit, an open records lawsuit in state court in New Jersey after Essex refused to turn over records about the termination of Professor Lisa Durden following her appearance on a Fox News show to talk about a matter not related to her coursework at Essex. She didn't even mention Essex. She was talking about a Black Lives Matter protest in Brooklyn. So let's go to my colleague with all the answers about Essex. Adam, what's the latest? What's happened since we last spoke?
Well, since, just for a little bit of background, what happened was Lisa Durden was an adjunct professor at this community college in New Jersey, and she went on a primetime Fox News program to debate Tucker Carlson about a Black Lives Matter event that she wasn't involved with.
Right.
It was taking place up in New York City. And Tucker Carlson's show is, like many of these cable news shows, kind of a punchy back and forth verbal sparring. She didn't mention that she went to Essex. Essex wasn't mentioned during this at all. It wasn't mentioned in the news coverage. Nobody talked about it on Twitter, or nobody talked about Essex on Twitter. But lo and behold, a couple of weeks after that appearance, Essex, or she came out and said, Essex let me go from my position, they suspended me, and they put out a statement saying, look, we were immediately inundated with feedback from students and faculty and prospective students expressing fear that, that these views might impact their interaction in the classroom.
Immediately inundated. All right, let's remember that phrase.
Well,
immediately inundated.
And the other thing he said, it was an immediate outpouring of concern.
Okay, so we're thinking tens of thousands of emails flooding into Essex County College, shutting down their servers.
At least tens of tens.
Yeah.
You could imagine being on Fox News, being watched by millions. If millions of people were outraged, then they might in mass send emails to a college administration, which, to be clear, if that happened, it would be the responsibility of the administration to say, well, this is just the cost of running a college, is that people are going to say things that might be controversial, and just because people are angry about them does not mean that we get to fire them. But that didn't happen.
Okay, what did happen?
We filed a public records request saying, hey, we want to see the feedback that you're referring to.
The outpouring.
The outpouring.
The inundation. Where was it?
So Essex repeatedly said, we'll give that to you, but give us another month, give us another month, give us another month. And eventually they said, we'll give it to you by something like November 20th or something like that.
Okay.
And blew past the deadline. Never gave us anything.
We first asked them in June, right?
Yeah,
and then
somewhere
took to
around
November. Okay.
And eventually we said, look, if you don't give us these records, we are going to have to sue. And they went silent. So right on the eve of the statute of limitations, we had no other choice but to sue to preserve the right to look at these records.
And that was earlier this month in January.
Yeah. I'm still disappointed that our lawsuit didn't start with the phrase, outpour your sugar on me.
Essex did pour out that sugar, and it turned out not to have much in the bag.
It was more of a packet of artificial sweetener.
Yeah, it was a little sweet and low. So what
Those records, if there was an outpouring of feedback immediately after this appearance, it's not in any sort of records anywhere.
Okay, what are we talking
There was one email in the first 13 days. One email from some random guy who has no affiliation with the college saying, if you don't fire her, I'm going to start a petition of some sort.
Wow.
By the time he had emailed them, they had already learned of the appearance and pulled her file. So before anybody complained, they had already started some sort of investigation.
For the inundation of one email, they were well
Zero
on their way.
emails.
And that one
right.
email, if I'm not mistaken, they actually joked around about. They said whatever town he was from Florida.
That
checking
came
in.
later.
Oh, that came later.
Once she went public and said, my school has suspended me, they got something like 30-some emails from people, mostly having nothing to do with the college because they were all across the country.
That's about like 12 minutes of time in Fire's life.
Yes, that is true.
And they were joking around saying like, oh yeah, here's someone from northern Florida emailing us.
Okay.
So they knew this was not, even if there was some sort of inundation weeks later, it wasn't really from people from the school.
It's not
They didn't take it
students.
seriously.
No.
Okay, so it's not students at Essex, it's not citizens in Newark, New Jersey, even citizens of the state of New Jersey. It's just kind of a generalized outrage from folks across the country. So to be clear, no inundation,
No inundation.
no server melting feedback.
No
They-
server
and they
melting
had
feedback.
already readied her termination or seemed to have taken steps towards reviewing it, and they let her go.
Yeah.
Okay.
But it was a convenient excuse to say, well, there were a lot of people mad, and that obviously impacted us when it didn't.
Now, this Friday morning, I know we're going to be publishing an update because Essex has responded to our befuddlement with what they were talking about. So Essex is now on record telling folks what? How are they justifying their actions here?
They're not. They're saying that we've mischaracterized their actions and then not explaining how we've mischaracterized it. So they've had 6 months to, at least 6 months to figure out, what is our story here, and they've come up with nothing.
Yeah.
The real beauty of public records requests, though, is that nobody has to take our word for it because we have the receipts.
Yeah, we published it. And worse, they are saying that they have hundreds of faculty members or hundreds of adjunct faculty members, and that they can be let go at any time,
Yeah.
which is not true. You can't be let go for a reason that violates the First Amendment. So what Essex is essentially saying is none of our adjunct faculty members enjoy First Amendment rights, and we're not going to stand up for them.
Let's be clear on that point, too. So what Professor Durden said, even if it offended most Americans, some Americans, 2 Americans, that's not enough to fire her.
No, she was speaking out on a matter of public concern in a public forum on national television.
As a private citizen, right? And she didn't even mention her affiliation with Essex.
Exactly. It had nothing to do with her performance in the classroom. In fact, the day of this appearance, they were adding classes to her schedule for the following semester.
So, but for this appearance, she would still probably be teaching classes in Newark, New Jersey, at Essex County College.
Yes.
I would highlight also that it's not just that the people who complained were unrelated and that she didn't mention her affiliation with Essex. Sometimes if a professor would say something that might be interpreted as an intent to discriminate against certain classes of students, if there's a credible reason to believe that that might have occurred on campus, then there might be room for a university to investigate at the very least.
Sure.
But there's been no allegation that she has treated any student differently on the basis of her race, and I think that's really important. That's the distinguishing feature between when university action might be appropriate and when they need to just let go and respect their faculty members' First Amendment rights.
That's right. That's right. And also faculty members, it's worth noting, have a right to criticize their schools, right? I mean, if she had gone on national cable television and said Essex County College is being mismanaged, and let me tell you about why, she would arguably have that right too.
Yeah.
Okay, for more on this story, be sure to check out our blog at thefire.org. You can see, as Ari puts it, the receipts. You can see what Essex handed over to us. You can read Adam's latest commentary on Essex County College, and I think we'll probably have more on that in the coming weeks, so stay tuned. Maybe we'll talk about it again. Thanks so much, Adam. Appreciate you joining us. All right, as Adam drops the mic, we will turn now to our next topic on this Friday morning. All right, Adam back to recover his inbox from the inundation of emails that is no doubt accumulated in these 10 minutes here. I bet you
it's probably more than Lisa.
Almost certainly more than 2.
About Lisa Durden.
I bet you it's at least 40, the way our inboxes work around here. All right, so let's talk now with Samantha Harris. Sam, we filed an amicus brief. I guess first of all we should tell folks what an amicus brief is, and then let's talk about what we did and why.
Yeah, so individuals and organizations like FIRE can file an amicus brief. It's called amicus curiae, means friend of the court. And it's when you're not an actual party to litigation, but the outcome of the case is likely to impact something that you are concerned with. So in this case, it's a case that's likely to impact First Amendment rights on campus. So FIRE, along with a group of other organizations, filed an amicus brief in this case to sort of give the court our unique perspective on the issues and on the implications of this case.
So what's the court and what's the case?
Okay. So this is a case that is on appeal to the U.S. Court of Appeals for the Fourth Circuit from a federal district court in Virginia. And it is a case involving a group of students who were part of a University of Mary Washington student group called Feminists United on Campus. And they were strong advocates for women's rights on campus. And in the course of doing their advocacy, they got involved in some campus controversies. They opposed a motion to recognize fraternities and sororities on campus.
Okay.
And they asked the university to punish the rugby team after some members of the rugby team were caught on video participating in a bawdy rugby chant at an off-campus party.
Right. And they were successful,
did,
right?
in fact,
right.
Suspend the rugby team. And so, some of their views were unpopular on campus. And at the time, there was this social media app called Yik Yak, which no longer exists.
Right.
But on Yik Yak, people within a certain geographic range, this is my best understanding of it. I've never used it myself.
Not a Yik Yak. Yeah.
I'm not a yacker or whatever you call them.
Yeah.
Sam's still stuck on MySpace.
Friendster.
It's tragic.
Friendster. So users within a certain defined geographic range can anonymously post comments to Yik Yak.
Anonymous users within a certain area,
yes.
And everybody can log on and see them?
That I'm not sure about, or if you need an account, but...
it's kind of the internet equivalent of scrolling on a bathroom stall wall.
Right, yaks.
In more ways than one.
Yeah, we filed a brief talking about yaks.
Some hostile comments about this group and some of its members started appearing on Yik Yak.
Okay.
And to be clear, some of them were pretty vulgar and pretty crude. They were angry responses to the plaintiffs' political advocacy on campus. And the plaintiffs argue, A, that this created a hostile environment for them, which violates Title IX, the university's obligation to protect them from sexual. So they argue that they've been subjected to sexual harassment and that the university is what we call deliberately indifferent to that harassment. That is, the university didn't do nearly enough in their estimation to address their concerns.
So in other words,
and they knew about it.
The university knew about these hostile yaks against the campus feminists, Feminists United on Campus, but did not take action.
Did not take sufficient action. There's no question that they took action.
Okay, well, let's talk about that. What did the university do when the Feminists United came to them?
They met with the concerned parties. They held some listening groups for people to air their concerns. In certain instances, they provided campus security to people who felt unsafe.
Okay.
And also, as I mentioned before, they did suspend the rugby team and take action against the rugby team.
But per Feminists United on campus, that was insufficient. What did they want to have happen?
Well, what they really wanted initially was for the university to ban Yik Yak.
Ban Yik Yak. But University of Mary Washington is public, so could they have banned Yik Yak?
No. As the president said, that would have raised significant First Amendment concerns. Anonymous speech is protected by the First Amendment and is, in fact, an important right because it allows people who might otherwise fear retribution to express unpopular opinions. So there was that angle to the. So they brought a suit against the University of Mary Washington, alleging A, that the university had been deliberately indifferent to their claims of harassment.
Right.
And B, so backing up a little bit, before they filed this federal lawsuit, they filed an administrative complaint with the Office for Civil Rights, which is the
United States Department
of Education, which is the federal agency responsible for the implementation of and enforcement of anti-discrimination laws on campus. And at the time that they filed the OCR complaint, they also held a press conference at which they slammed the university for its lack of response.
Right.
And in response to that negative publicity, the president of the university at the time, Richard Hurley, published an open letter actually to a national feminist organization that was supporting the student plaintiffs in their filing of the OCR complaint, basically rebutting their allegations.
So he said, I can't do anything, this would violate the First Amendment?
He brought up the First Amendment.
Yeah.
Not only that, but high schools since the 90s have learned that trying to ban a website or web service doesn't really work ever.
The practical questions, and also pointing out that he had, in fact, and the administration had, in fact, taken steps to address the concerns that the students had.
Right. So he didn't say, these are terrible people. He didn't.
Right.
He said they're wrong.
Right.
He said they've come out and made these allegations publicly, and these allegations are untrue.
Right. Okay.
So the plaintiffs amended their OCR complaint to add a retaliation claim,
based on
alleging that Richard Hurley's public response
Okay.
to the allegations against the University of Mary Washington constituted impermissible retaliation, right? Because you can't retaliate against someone for complaining about sexual harassment.
Right.
And that's legitimate.
enough,
Totally
sure. Of
fair
course,
enough.
yeah.
But publicly responding to allegations that you have engaged in wrongdoing is not retaliation. And in fact, if it were to be construed as retaliation, then Title IX would basically be allowed to function as a gag order,
Right.
where people could come out and make serious accusations against you, and you would be powerless to say anything in response.
Okay.
So their lawsuit, which was filed after the OCR complaint, also included this retaliation.
Okay,
claim.
so the student group files a lawsuit, and that is in federal district court, alleging that the president's comments constituted retaliation, and also that the University of Mary Washington had been deliberately indifferent in responding to harassment that the Feminists United on Campus had complained about. So what did the district court rule?
So the district court ruled in favor of the university and the president. They said university hadn't been deliberately indifferent, and that the comments were not retaliation.
And that was last fall?
In September, I think.
September.
And the plaintiffs have appealed that to the Fourth Circuit.
Okay, so now this is where fire comes in.
Now, there's an important reason that we wanted to weigh in, and it's that there's an important First Amendment issue that hasn't been considered in this case. When the district court looked at whether the university had been deliberately indifferent, it assumed, for the sake of argument, that the speech that the plaintiffs were complaining about was unprotected harassment. But in fact, if you look at the exhibits that the plaintiffs attached to their complaint, which were, the yaks, yaks are the name for like posts on Yik Yak, the posts on Yik Yak that they considered the most offensive. They're not harassment, or they're not threats. They're offensive but protected speech. But nobody had actually considered this argument. So, that gave us a reason that we felt like we really wanted to go on the record and say, hey, listen, we actually think the court got it right on deliberate indifference. But before you even get to that, because the Fourth Circuit is going to be doing what we call de novo review. They're going to be considering the case essentially anew.
Right.
And so what we wanted to say is, look, before you even get to the deliberate indifference analysis, you need to ask whether this speech was even unprotected. And we're going to demonstrate, by case citations and by, everything, that it was not. That in fact, this speech was entitled to First Amendment protection and couldn't be considered
it wasn't
harassment or threats in the first place.
Wasn't true threats.
Right.
Didn't fall under any of the narrow.
Right.
Oh, I guess you should say it's not harassment in the legally
In the
cognizable
legal,
sense.
correct.
I mean, the colloquialism that, and the casual nature in which people throw around words these days has really turned the word harass into basically say something mean.
Right.
Right.
Which,
Okay.
Because harassment is contextual. I mean, some of these things that were being said, if the people who'd been posting on Yik Yak had instead been following the plaintiffs around campus shouting these things,
Sure.
that might have been harassment, because that might have legitimately changed the way the plaintiffs went about their business on campus.
and that's the conduct of following them
Right.
around plays into it too.
But these were posted on a website that plaintiffs had to opt in to voluntarily go to and look at.
Right.
They were not sort of unavoidable. There was not a captive audience situation happening where plaintiffs couldn't avoid these comments.
Okay.
Right. I can't go into Will's office and while he's talking and saying something I don't like, and then sit down on his couch, sit there for a half an hour and say, Will Creeley has just harassed me.
I might remind you that sometime.
With whom do I file a complaint?
I appreciate this valuable concession to my, my administrative authority here. Okay, so Fire weighs in. Who joined us on the brief, Sam?
So a couple of other groups, the Cato Institute, the National Coalition Against Censorship, and then Professor Nadine Strossen, who teaches law at New York Law School and is former head of the National ACLU.
Right, okay.
And then another group, the Electronic Freedom or Frontier Foundation,
EFF.
Filed their own brief focused on the issue of anonymous speech and the importance of protecting the right to anonymous speech. Because although FIRE totally agrees with that, that wasn't the specific focus. The nice thing about amicus briefs is it gives groups an opportunity to bring their particular expertise to bear on a case and give the court some information that it might not otherwise have.
Right, and EFF, Electronic Frontier Foundation, terrific organization. We've been honored to work with them many times. They do civil liberties in cyberspace. Ari, what was their
real
argument?
cutting edge stuff.
Yeah, they're a fascinating group. EFF.org. What was their argument?
Well, I mean, the whole history of our country is based in anonymous speech. The Federalist Papers, hugely influential in the formation of our democratic republic, they're based in completely anonymous speech that people in tough times can make without fear of official repercussions or persecution. And if we lose that right to speak out anonymously, it really portends the end of our free speech tradition more generally.
Right.
Because once you lose that right to engage in anonymous speech, and particularly anonymous criticism of government officials and things of that nature, then it's really only a matter of time before that forced identification turns into repression.
Right, and I think one of the interesting things about EFF's brief, which we linked to in Sam's recent blog entry explaining our brief, is that EFF points out that, as Ari says, anonymous speech is important and powerful, and students can use Yik Yak or other anonymous portals not just to be nasty to one another, because the yaks at issue here are not the Federalist Papers. I mean, they are, as Sam puts it, they are crude, as the Cato Institute put it.
I don't know, I've spent the last 2 days actually typing the entirety of the Federalist Papers into anonymous websites.
Right, but EFF makes a great point that students had been using Yik Yak in a variety of ways in terms of organizing, finding others of like mind, discussing difficult issues that they didn't want to attach their names to, issues of sexuality or political organizing or difficult situations of all kinds.
Can be used to send out a warning saying, hey, this person just attacked me in, X location, beware, because it's geofenced in that way that, it's helpful sometimes.
Yeah, so EFF makes the point there are lots of social and political uses for anonymous speech, and if you grant the complainant's point of view here and posit somehow that University of Mary Washington had an obligation to crack down on anonymous speech that they didn't like, you open the door to a host of problems, and you really shut down one of the few places, one of the unalloyed goods of anonymous speech that allows people to talk to each other in clear and concise ways. So I urge you to check out the EFF's brief as well. Sam, what should we expect for timeline here? Is this months and months?
That is very hard to
Right.
say. I mean, as someone who, for other aspects of my work, follows a lot of cases, it can vary widely. I believe that the plaintiffs who are appealing filed their opening brief, then the appellants, the university filed their brief, and I believe that just a few days ago, the plaintiffs filed their reply to the appellant's brief. So there's still some briefing happening.
Gotcha.
So it's not going to be decided next week, but we will tell you about it when it is decided. We're obviously going to be keeping a very close eye on it. So
Right. So I urge folks to check out our brief. Important to note, the National Coalition Against Censorship is a big coalition of groups, and they signed on, but their views in the brief do not necessarily reflect views of their member organizations. We've written a lot about University of Mary Washington over the last couple of years, so it's a very interesting question, and I think the decision will be one to watch.
yeah, and if you go to our Spotlight database on our website and you search for the University of Mary Washington and then click on the commentary tab, you can go back a couple of years and see, we wrote about the rugby controversy when it happened. Yeah. You can sort of follow this case from its inception. So.
Right, and this one's gotten a lot of headlines from Jezebel to Slate and elsewhere. So definitely one to watch, and we will keep you posted. Well, thank you so much, Sam. Thank you so much, Ari. Any last words? We good?
Yeah.
We're good. All right.
TGIF.
Thank you. Thanks, everybody. Have a good time on the internet.
But not on Yik Yak.
Not on Yik Yak.